Welcome back to Lost Touch channel. My name is Anton Vieltsin. I'm an attorney in the Southern District of California here in San Diego. Today we're going to discuss the Fourth Amendment and specifically curtilage, which is an area right outside of your home. The case is going to be about law enforcement following a suspect into that area without a warrant and without any exigency. I'll explain more later, but for now, let me first thank you for watching me on YouTube and hitting that subscribe button. If you're listening to the podcast version of this recording, please give my podcast a 5-star review rating. And finally, if you want to support my channel, consider going to loststash.com and checking out some of the merch, including these Do Not Arrest This Person t-shirts. Thanks for watching.
Quick message from Law Stash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Law Stash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Law Stash YouTube page. That's LAWSTACHE.
Today we're discussing a Ninth Circuit case, United States versus Perea-Rey. First, let me give you some factual background. Border Patrol agents observed an individual climb over United States-Mexico border wall and enter United States. They then observed this individual get into a taxi.
If you're a person on the go, write down this number. It's the key to traveling quick. It's Casino Taxi's number, 4296666. Casino Taxi, they're the fast ones. Casino Taxi, near as your phone. No need to run, don't get wet, dial the number, 4296666 or 4256666.
And they followed him to the house of Mr. Perea-Rey. They then observed this suspected illegal alien knock on the front door and later instructed to have him walk around the house through the carport area to the side door to the house. One Border Patrol agent followed this individual, and instead of knocking on the front door, he simply walked to the carport area where he found the suspected illegal alien and Mr. Perea-Rey. He detained both individuals. When Mr. Perea-Rey refused to allow the agent to enter his home, forgetting that the Fourth Amendment applies and that generally speaking law enforcement need to have a warrant before they enter the home, the agents took out their firearms, pointed at individuals, and ordered everyone out of the house. More people came out of the house that were all suspected of being illegally in the United States. Arrests ensued, and Mr. Perea-Rey was charged with 8 U.S.C. 1324 harboring illegal aliens. He then filed his appeal after losing his suppression motion at district court level, where he said that the evidence of illegal aliens should have been suppressed as fruits of the poisonous tree, meaning that the entry into his curtilage and his house was in violation of the Fourth Amendment. Remember, the Fourth Amendment protects against unreasonable searches and seizures, and generally speaking, officers need to have a warrant before they conduct that search or seizure. Here, they didn't have a warrant. The Border Patrol agent simply walked into the carport area of Mr. Perea-Rey's home. I will include some pictures of the house which were conveniently attached as exhibits to this appeal. So take a look at how the house looked like and the whole layout. The Fourth Amendment protects you against unreasonable searches and seizures, where the government physically occupies private property for the purpose of obtaining information. That is a search within the meaning of the Fourth Amendment. Searches and seizures inside a home without a warrant are presumptively unreasonable. Because the curtilage is part of the home, searches and seizures in the curtilage without a warrant are also presumptively unreasonable. The determination that a particular search did or did not occur within the curtilage must be reviewed de novo on appeal. The district court found that the carport area, which the Border Patrol agents occupied, was part of the curtilage of Mr. Perea-Rey's home. And the appellate court agreed. The appellate court examined 4 non-exhaustive factors to determine whether an area is part of a home's curtilage: the proximity of the area claimed to be the curtilage to the home, whether the area is included within the enclosure surrounding the home, the nature of the uses to which the area is put, and finally, the steps taken by the resident to protect the area from observation by people passing by. This is from the case United States v. Dunn. Here, the carport was directly adjacent to the home. It was enclosed by walls, had a roof, and had a gate in the front. It was also used to store valuables that Mr. Perea-Rey had, including his vehicle. The appellate court said that all of the Dunn factors were satisfied, and this in fact was curtilage and had the Fourth Amendment protections. When we usually talk about the Fourth Amendment, we discuss the reasonable expectation of privacy test. That is because in order to invoke the Fourth Amendment, an individual has to show standing, meaning reasonable expectation of privacy. But since the case Jones, the Supreme Court has reminded us that the reasonable expectation of privacy test was not a substitute, but an addition to the common law test, which was always trespassory test. If the government trespasses on your property, that would be deemed a search under the Fourth Amendment. The Supreme Court has explained that the role of reasonable expectation analysis in evaluating the constitutionality of searches of the curtilage is only in determining the scope of the curtilage and not the propriety of the intrusion. The extent of the curtilage is determined by factors that bear upon whether an individual reasonably may expect that the area in question should be treated as a home itself. The district court also conflated the ability to observe inside the curtilage with the right to enter the curtilage without a warrant. Although a warrant is not required to observe readily visible items within the curtilage, and officers need not shield their eyes when passing by a home on a public thoroughfares, a warrant is required to enter the home. The appellate court concluded that the Fourth Amendment applied to the carport area, the curtilage of Mr. Perea-Rey's home, and officers needed a warrant in order to enter that area. Now let's talk about some exceptions. We know that generally exigency and emergency are some of the exceptions to the Fourth Amendment warrant requirement. If there's an exigency, officers can enter the home without a warrant. Interestingly enough, the government here does not argue these exceptions. Instead, they rely on the knock and talk exception. We know that officers can approach the curtilage and even enter that area in order to initiate a consensual conversation with occupants. But it has to be consistent with what public would do when they try to engage with occupants of the home. Here we know officers did not do what the public would do. They, in fact, observed the undocumented alien knock on the front door, and then he was given permission to go through the side to the carport area. Here, the officer never even tried to knock on the front door. Instead, he simply entered the carport area. There, instead of trying to start a conversation with Mr. Perea-Rey, instead, he detained him right away, never asked any questions, and instructed other individuals to exit the house. If we were to construe the knock and talk exception to allow officers to meander around the curtilage and engage in warrantless detentions and seizures of residents, the exception would swallow the rule that the curtilage is the home for the Fourth Amendment purposes. Finally, the Ninth Circuit holds that the warrantless entry into Mr. Perea-Rey's curtilage violated his Fourth Amendment rights. If you enjoyed this video, if you learned a little bit about the Fourth Amendment, what curtilage means, and how the officers need to have a warrant before they enter that area, please hit that subscribe button and the thumbs up button. and share my video with your friends. I'm trying to grow this channel, and the more people know about it, the bigger it gets. I appreciate you for watching it. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star review rating. And finally, if you want to support my channel, consider going to loststash.com and checking out some of the merch, including these Do Not Arrest This Person t-shirts. Thanks for watching.